I'm James Davidson, and this is my brother Matthew Davidson. And we're the principal attorneys at Davidson Law Group. The Davidson Law Group, we're a comprehensive estate planning, elder law, and probate firm with offices in Fort Worth, Allen, and Tyler, Texas. And so today we're going to be talking about some general estate planning considerations. But before we do that, we kind of want to go over why we got into this area of practice in the first place. And it really stems from a desire to help people in their time of need. And in reality, we have a very personal experience that sort of lent us to that, and it has to do with our maternal grandfather. And so our maternal grandfather was a World War II veteran, fought in the war, and came back to the United States, and got his college degree, married my grandmother, and worked for International Harvester his entire life, and then retired and moved with his family to Austin, Texas. Like any good retiree, he went and saw an estate planning attorney and had his will done, his powers of attorney, and he thought that he was covered. Well, in 2008, it started with a fall, and that fall led to a stay in a rehab facility. And before we knew it, both my grandma and my grandpa had completely moved out of their home and into a long-term care facility. And we watched my mother, who was their primary caretaker, tirelessly care for them over a period of 7 years before my grandfather died. And at the time that he died, he had lost everything that he had spent his entire life accumulating and earning. And now my grandmother, who's 98 years old, is still alive and living in a long-term care facility in Fort Worth. And my mother and her siblings are having to pay out of pocket every month so that she doesn't have to go on Medicaid and she can have the level of care that we all as a family desire for her. And so with that experience and seeing what that did to my mother and what that did to our family, we really have a desire to help people in their time of need and to ensure that hardworking people do not lose everything that they spent their entire life earning.
So that was why we got into it in the first place. And in just a second, we're going to dive into some of the basics of estate planning before going into some other considerations.
All right, so first and foremost, we're an estate planning law firm. So let's take it back to the basics. What is an estate? And then what is an estate plan? So a lot of times when people hear the word estate, they hear it like this: estate, like the lifestyles of the rich and famous, or the Rockefellers or the Kennedys. But really that's not accurate, because everybody has an estate, and therefore everybody needs an estate plan. So if you have things, right? You have furniture, you have jewelry, you have collections, you have a car, then you have personal effects, and therefore you have an estate. If you have a bank account, or an investment account, or insurance, then you have financial assets and you have an estate. If you have a home and you have any other real estate, then you have an estate. Even if you don't have any of those things, you still have an estate, because our medical affairs are part of our estate. As well as if you have minor children or special needs family members, then also your family affairs are part of your estate as well. So the question is not whether you have an estate, but who will create your estate plan. And if you don't have documents in place that talk about who's going to get your things, your personal effects, your financial assets, your real estate, then the probate court's going to decide for you. And the laws of the state of Texas are going to decide for you who gets those things. If you don't have provisions in place for minor children or special needs people in your family, then the family court's typically going to decide what happens to those people. And so we don't want the probate court or the family court or the state of Texas in our cold, objective laws to decide what's going to happen with your estate. We want to put you in charge of your estate. We want you to create your own estate plan. So when we're talking about creating an estate plan, here's a little bit of a high-level description of what we're talking about. What's going to happen to me or my loved ones if I become disabled? Incapacitation planning is a major consideration. And whenever we're talking about making plans for these, powers of attorney are essential. A durable power of attorney to make sure that somebody's in place to take care of your financial affairs if you're unable to do so. A medical power of attorney to make sure that someone's in place to take care of medical decisions if you're unable to make medical decisions on your own behalf. An appointment of guardian, especially for minor children, if you have minor children, or for special needs people in your family. or in some cases, adult guardianship. In cases of dementia, Alzheimer's, you need to make sure that somebody's in place just in case you as an adult ever need a guardianship. And then finally, as we'll talk about a little bit later on in our presentation, trust planning also has a lot of incapacitation planning components built in. So you want to make sure that you have these documents in place to decide what happens to you or your loved ones if you become disabled. Now also, what happens to your assets? What happens to your things upon your passing? You don't want the probate court or the laws of the state of Texas deciding these things for you. So that's why you need a will at the very, very least. You might need a trust depending on your situation. And then in some particular cases, there are certain types of deeds that can take care of what happens to your home or other types of real estate whenever you pass. But the takeaway here is that you just want to make sure that you have documents in place that say who's going to get my things whenever I pass away. So that's kind of a basic overall look at estate planning, and that's really dispelling the inaccurate thoughts that people have. Well, I don't have an estate because I don't have anything. Well, you do, and I just described it to you, and these are the documents that you really need to get in place to talk about your estate. Now that we've hit the basics, let's go into some real specific problems that we see as part of our practice in just a second.
So let's talk about the first problem. The first problem is the problem of intestacy or intestate. So the laws of intestacy, or the laws that are in place in the state of Texas that determine where your assets go when you either don't have an estate plan or you have a defective estate plan. And a lot of times these laws do not reflect what your wishes would be, especially if you are a blended family or you have estranged family members out there somewhere. And so for blended families, it oftentimes is extremely devastating because literally you might have had a child early on in life and then married the love of your life and had children with that spouse. And then if you didn't have a plan, you would divide your estate in half. One half would go to that first child, and then your spouse would retain the remaining half. And so that's just a quick example of how it can be absolutely devastating for blended families or families who have estranged members out there somewhere. And so that's the intestacy problem. Now let's talk about the probate problem. So I'll give the caveat, in the state of Texas, the probate process is not too bad as compared to other states. However, it is a principal part of our planning to avoid the probate process when we possibly can. And so why? Ultimately, because of the high fees. Now, in best case scenarios, it's ultimately not that expensive. But there are scenarios out there where we don't get the best case or the best facts, where it does become extremely expensive and it can be drawn out for a long period of time. Also, when you file for a probate of a will or any sort of a probate, you file a lawsuit, okay? And that lawsuit creates vulnerability for the estate and the estate assets to potential creditors. So you could have a creditor file a claim and they have to go through the process of validating that claim, but ultimately you have to deal with that claim whether it's valid or not. And so ultimately it creates that vulnerability that you could otherwise avoid by avoiding the probate process. Also, when during certain types of probate, the accounts can be frozen, and perhaps a surviving spouse can have limited access to much needed funds to, let's say, pay bills or sort of keep status quo. And when you're dealing with the loss of a loved one, that is the last thing you want to do. And then ultimately, if you have minor beneficiaries and you want to provide for those minor beneficiaries, going through that probate process can, again, be lengthy, and the funds can be frozen and ultimately not benefit your minor beneficiaries in the timely manner and in the manner that you would want to normally as a parent. And so ultimately, again, the probate process is not the end of the world, but there are some simple and easy ways that we can accomplish avoiding the probate process, and that's why it's a principal part of our planning process. So what are some estate planning solutions? Okay. First of all, there's the last will and testament, and everybody's heard of a last will and testament. So what a last will and testament does is it gives instructions to a probate court about where your assets go upon your passing and who is going to administer your estate. Okay? And that person is typically called an executor or an independent executor. And so that last will and testament is a fundamental piece of any estate plan. Okay? Everybody needs a will. But the problem is, and if you want to call it a problem, is that with a will, you do have to go through the probate process. And so through the use or utilization of other types of estate planning tools, like a trust or like a deed, you can avoid that probate process altogether and ultimately avoid those problems that we highlighted in that previous slide. And so now we're going to transition and talk about some of the different types of trust planning that we use in our practice.
Okay, so now we're going to talk about two of our most common niche trust plans that we do in our firm. I'm going to talk about our legacy planning through revocable living trusts, and then James is going to talk about long-term care planning through long-term care trusts. So revocable living trusts are actually very common, and they've been used for decades, but typically they were used for a couple of reasons. One is just to avoid probate, and then the other was some estate tax type of planning. However, in this day and age where most of our clients don't have a problem with estate tax, and as James mentioned before, Texas is not the worst state for probate, so we really look at revocable living trusts as an opportunity to do more than just probate avoidance and do more than just tax planning, but to really do what we call legacy planning. And here are some of the bells and whistles that we build into our revocable living trust that enable us to accomplish a legacy plan. So the first one I would hit on is how incapacitation is determined. I mentioned and James mentioned that we do a lot of incapacity planning. However, traditionally, attorneys have just said, all right, if two independent doctors say that this person can no longer manage their financial affairs, then that's the case. But we like to keep it within the family. So within our revocable living trust, we do panels of family members who will actually make this decision for the incapacitated person rather than just the cold, objective opinion of two doctors. Also, one problem that we've seen that affects people's legacy is when a married couple comes to us, they do an estate plan, one spouse passes away, and then the other one gets remarried. And then sometimes we see it where that spouse then leaves everything to the new spouse, and the kids from that original marriage are the ones who really get left out. And we want to prevent that. So we build into our trust that whenever one spouse passes away and the other one wants to get remarried, then we require a prenup. And we also put some special parameters in there to make sure that the kids can't get left out in the cold in favor of a new spouse. Finally, creditor protection is a big part of legacy planning. Creditor protection is hard to get in estate planning. So we take every opportunity to build it into our trust where we can. And this helps to protect assets for a surviving spouse, but also for children from divorces, from bankruptcies, from car wrecks, from any other types of lawsuits that are out there. Also, we have to plan for minor children and sometimes adult children who may not be the most responsible with money. And so with this, we build in something that we often call trustee training wheels, where we say, okay, at a certain age, we're going to let our child then serve as a co-trustee with whoever is managing the money for them. And then finally, at the age where we think that they're mature enough to handle their inheritance, we allow them to have their full control over their inheritance. And then finally, with our revocable living trust, a lot of our clients want to make these a descendants only or a blood trust to make sure that down the line generationally, that the inheritance that our clients have worked so hard to be able to make, to give to their children, ends up staying in their family and doesn't end up in a place that they didn't intend for it to be. So those are just a few of the components of a revocable living trust at Davidson Law Group that really centers around the idea of legacy and setting things up in a purposeful and intentional manner for the next generation. And so now James can talk a little bit about long-term care planning.
Sure, absolutely. And so long-term care trust planning is an increasing and ever-increasing part of our practice. And what long-term care trusts do is provide a solution, and oftentimes life-changing solution, for clients who are facing a long-term stay in a long-term care facility of some sort. So that's the solution. And the problem is, and the reason why this is an increasing part of our practice, is that age group of 65 and older is growing dramatically. And so with that growing number of folks who are 65 and older, plus the rising costs of long-term care and the extension of life expectancy due to our high levels of medical care, it creates this problem where folks are spending a long period of time in a long-term care facility and are having to private pay with their assets and ultimately carve out a significant chunk of those assets or lose it all altogether to pay or to fund for that long-term care stay. And so for married couples, oftentimes that can provide problems for the non-institutionalized spouse who may have a long life to live ahead of them, but have now spent all of their money to provide the level of care that they want and desire for their loved one who is facing a long-term care stay. So that's the problem. And long-term care trusts are a significant life-changing solution to that particular problem. And so what are long-term care trusts? Well, there are trusts that are specifically designed to protect assets and to help the client qualify for some sort of government subsidized payment to help pay for their long-term care stay. And so depending on the facts and the circumstances of the client, well, maybe they're a wartime veteran or the surviving spouse of a wartime veteran. Well, there's a benefit for those wartime veterans or surviving spouses of wartime veterans called Aid in Attendance that is designed to help those folks who are 65 or older and who need help with at least 2 activities of daily living. And so it's tax-free money that goes into your bank account that you can use to help fund that long-term care stay. And so for a veteran with a spouse, it's somewhere around $2,300. That is the maximum benefit. Or if you're the surviving spouse, then it could be somewhere around $1,300. Now that's the maximum benefit, but that money goes directly into your bank account and you can then turn around and use it to help subsidize your long-term care costs, okay? And so that's something that we use for our veterans. Now, this program, in addition to Medicaid, are all asset and income-based qualification programs. And so what these trusts do is they help you in terms of the asset and sometimes the income qualification. And so whether it's VA Aid in Attendance or we're looking at Medicaid, which is a federal and state program that helps those who qualify fund their long-term care stay, oftentimes in its entirety. And because these are asset and income-based qualifications, we have to look ahead because we are subject to what are called look-back periods, which I'm sure a lot of you are familiar with. And so if you're looking to qualify for Aid in Attendance, well, they're going to look back 3 years and see if you've transferred any assets or gotten rid of anything and not received market value in return. And if you have, they're going to subject you to a penalty period. Same thing with Medicaid. You're going to be subject to a 5-year look-back period. They're going to look back in that 5-year window and they're going to see, well, hey, did you deed the house to your children or did you give too much money away? And if you have, they're going to subject you to a penalty period. And so the solution to that is, one, to recognize this potential problem and to get ahead of it with what we call pre-planning, where if we can establish one of these trusts and we can fund your assets into these trusts and we can make it the 3 years or we can make it the 5 years and we can protect everything that we have in the trust, qualify you for that government subsidized program, okay, and then supplement on top of that program with the money that we have protected in the trust. And so for many folks, as I alluded to earlier, this is life-changing and can save hundreds of thousands of dollars to, one, leave a legacy to your children, but two, to also enhance the level of care and provide supplemental sources of income that could potentially be life-changing for families. And so these are just some of the quick examples of how we utilize revocable living trusts and long-term care trust planning in our firm.
Yeah, that's exactly right. And as we kind of wrap up here in a second, I'm going to offer just some of my final tips and a little bit about the way that our firm operates. All right. So now I just want to hit on some final tips just to make sure that your estate plan is still working for you. You may have said, well, Matt and James, I've already done this. I did this 10 years ago with so-and-so law firm, or I did this on LegalZoom. Well, let me just hit a couple of things just to make sure that you're good. So one of the biggest things I see is making sure that your estate plan still reflects your current wishes.
I can't tell you how many times we've seen somebody pass away and there's still a child that maybe is estranged from the person and they're still left as a beneficiary, or just in general, maybe people involved in the plan that if you had updated it in the last 5 years, you might not want involved in the plan anymore. So I would just say, take a look at it and make sure that everybody involved is who you want to be involved. Also, one of the things that we're seeing these days is the concept of powers of attorney becoming stale. You know, it's very subjective for a bank or for a hospital in accepting a power of attorney, a durable power of attorney or a medical power of attorney. And what we're seeing is that in this day and age of fraud and identity theft, that if that power of attorney is too old, then you may run into issues with them accepting it. And so we're typically telling our clients it might be a good idea, even if nothing's changed in your circumstances, to get a new power of attorney done with a brand new date, maybe every 3 to 5 years. Another spot is just making sure that you hit everything that you want, you're protected in the right places. One of the things recently, we had this brand new piece of federal legislation called the Secure Act, which dramatically changed the way that inherited qualified money, like IRAs and 401ks, is treated for your children or for your family members. And so we've changed the language in all of our documents to reflect this new piece of legislation. So this may be a piece that if you have an IRA or a 401k, you may want to make sure that you're protected in the right place. Another component is the idea of providing for a pet after you're gone. We're seeing more and more of this, making sure that a pet that you love that's like a child or a family member to you is taken care of and not just left out in the cold if you pass. Another big part that we're seeing people not really protect themselves on is if you're a business owner and you have not made a succession plan for your business or laid out the way that you want your business to be run or to pass to the next generation if something were to tragically happen to you. And so if you're a business owner and you have not adjusted for your business in your estate plan, this is a place where you really need to make sure that you're protected. Now, the reason I say all of that is we do offer a free consultation at our firm. So if any of those pieces may have struck a chord, it can't hurt you to call our office, bring in your docs, let us look at them, and just go over these pieces to make sure that you're covered in all the right places. There's some things about our firm that are different than a lot of other practices, and the first thing we would say is we believe in helping our clients throughout their entire lives. It's not just a one-off transaction where we create documents. It's not just about the documents. It's a lifetime planning process. And so by offering a free consultation, we make this an easy, pressure-free type of relationship. Also, we don't bill by the hour. When you bill by the hour, it leaves this kind of unsettling feeling of what is this eventually going to cost me? That's why we set flat fees for basically everything within our firm. Also, whenever we do trusts with clients, we make sure that those trusts are properly funded. Can't tell you how many times that we have situations where another attorney did a trust for somebody, that person passes away and their kids come to us and want us to administer the trust, and we say, I'm sorry, ma'am or sir, there's nothing in this trust. Well, we were supposed to avoid probate. Well, that's why you need to properly fund the trust. And finally, something that's very different about our practice is to ensure that clients are taken care of throughout their whole life. We do something called the Client Care Program. This is something where we have different aspects where, one, we do an asset alignment meeting. This is to make 100% sure that any trust that you've done is funded. Also, we can't tell you how many times that the family members involved in the plan have no clue what to do whenever somebody passes away. So we do a family meeting for clients in our Client Care Program to make sure that those kids or those siblings or whoever you put in charge of your plan knows exactly what to do when crisis hits. Finally, when updates happen, like legislative updates, the Secure Act I mentioned before, we prompt you to make sure that your plan now reflects those updates. We do exclusive events, seminars, dinners, all kinds of different events for our Client Care Program clients. And then also, if you do need to make changes to your plan, you get priority access if you're part of the program. So these are just some things that really make us different, that set us apart. We've been very purposeful and strategic about doing things to make sure that our clients are taken care of throughout their whole lifetime, that it's a relationship and it's not just about the documents. And these are some of those pieces.
As estate planning attorneys, we see it as our job to provide you with the information that you need to make an informed decision about your planning. So if anything that we've talked about today has prompted any sort of a question, please feel free to take advantage of scheduling a free consultation so that we can go over that question. Or you can utilize our other methods of either submitting that question to info@yourtexaslegacy.com, or you can comment below this video, or you can feel free to reach out to us and message us on our Facebook account.
Yeah, thank you so much for taking the time to watch this video. We hope that it was helpful and informative and it blessed you. If you do have any questions, feel free to reach out. Otherwise, we wish you and your family the best.